Thank you for coming. Let's get the important things out of the way first. As you may have seen from the email, we're departing from our usual post-seminar practice today. So rather than going to the King's Arms, we're going to stay here. So drinks and nibbles will be served there'll be a short delay while they are served at 5 o'clock. So anyone who wishes to hang around and continue the discussion after the seminar, please feel free. You're very welcome to do so. Welcome to the second event in the University of Birmingham Comes to Oxford seminar. So it's my great pleasure to introduce Dr. Silvana Tapia from the University of Birmingham, where she is currently a Leverhulme Trust Early Career Research Fellow. Dr. Tapia she is qualified as a lawyer in Ecuador, where she also taught law for several years. She has a PhD in social legal studies from the University of Kent and is the author of the recent book, Feminism, Violence Against Women and Law Reform, Decolonial Lessons from Ecuador, which published in 2022. She's now going to talk about, I guess, her current project, the title of which is on the screen behind her and me, in front of you. So without further ado, thank you very much for coming. We're very much looking forward to this, and the floor is yours.
Thank you, and thank you everyone for coming. I'm really happy to be with you today. And I'm going to be presenting a talk that comes from this project, which is funded by the Leverhulme Trust. The project is entitled Toward a Non-Penal Human Rights Framework to Counteract Violence Against Women. And the goal of this project is to develop a different approach to human rights by drawing on the experiences of activists and organizers who are countering both violence against women and carceral violence. To develop innovative and why not subversive approaches to using the language and tools of human rights with a focus on addressing women's material needs. So I integrate here some anti-colonial approaches to justice and gender, anti-carceral theory and practice, and some ideas from social and economic human rights. But today's talk is entitled Anti-carceral Feminist Responses to Human Rights Penality in Ecuador and the UK, and I'm going to first speak a little bit to the background of this project and of this particular presentation. So the radical questioning of the role of prisons in a fundamentally unequal world is more complex than it seems, because it's not only opposed to an institution, but to a way of interpreting reality. Prison is not only a space in which political, social, and economic inequalities from outside are reinforced, it is also a symbol and a goal that lies at the foundations on which the edifice of today's globalized legal discourse is built. Although not always explicitly mentioned, prison underlies representations of justice in popular culture, news reporting, educational systems, social media, and citizens' imaginaries. Put in a different way, prison is discursively conflated with justice. And this conflation is not only legal, but also cultural. So when we think about the intersections between human rights and prison, perhaps many of us evoke the limitations that human rights impose on penal power and campaigns against inhumane and degrading treatment and punishment. Indeed, severe forms of violence in prisons are framed as violations of human rights. However, paradoxically, this framing often resorts to the very penal power that is being denounced as a main pathway to access justice, potentially leveraging and legitimizing prison expansion. And the closeness between prison and human rights is not always so easy to recognize. Within the dominant discourse on justice, rights must be claimed, and their violation must be reported. This means that the notion of rights is largely judicial and procedural. The dominant discourse links rights to legal processes, and many of those processes are of a penal nature. Typically, calls to trigger the penal apparatus are rationalized through a discourse by which the abuse of penal power can be curbed through formal law, and the criminal legal system can correct itself. Despite empirical evidence on the contrary, penal power is conceptualized as susceptible to moderation through due process and human rights principles. The idea of a humane penalty is in turn linked to the belief that we can have human rights compliant prisons. In reality, living conditions in prisons and detention centers around the world continue to reveal systemic forms of oppression that impact on the most marginalized and stigmatized sectors of society. In addition, social struggles, when judicialized, must adjust their language to the technicalities and formulas of law. Because the notions of justice and rights are intertwined with penal mechanisms, many social struggles have also become struggles for punishment. We are often facing campaigns that have professionalized themselves through legal knowledge and have translated their goals into the language of law and rights. They have done so because, in intelligible terms, that is what justice is. In this model, strengthening the rule of law is often about fighting impunity. Impunity is largely understood as the absence of criminal prosecution and punishment. To a large extent, the rule of law is the rule of penalty then, and rights-based claims become legitimate and attainable through legal and penal frameworks. Indeed, in the realm of violence against women, today's dominant approach centers criminal prosecution and fighting impunity, which is to a large extent also promoted by international human rights discourse, including through bodies such as the Inter-American Court of Human Rights and the European Court of Human Rights, which have coincided in framing states' due diligence as an obligation to criminalize, prosecute, and punish violence against women. In recently published work on violence against women, I argued that this human rights penalty is founded on a colonial reading of reality, a jury-defined approach to justice, and a liberal understanding of rights, which tends to overlook structural inequalities, women's material needs, the patriarchal violence of the penal process, and the real-world difficulties women face to access effective protection. In other words, human rights penalty establishes a narrow model of justice that tends to sideline, for example, socioeconomic inequalities and issues that contribute to violence against women and are also obstacles to overcoming it. The prospect of an anti-colonial, anti-carceral feminist approach to violence against women emerges here. There are individuals and groups that recognize gender-based violence as a systemic, structural, racialized, and linked to poverty issue. And at the same time, these people denounce the violence exercised by the carceral apparatus as a key part of the same oppressive structure. In many ways, these groups exist outside accepted and acceptable discourse on what justice is. What does it mean then in a world where justice is profoundly juridified to occupy a space of resistance to both gender-based violence and prison violence? What does it mean to occupy this space vis-a-vis law, rights, and more specifically in relation to human rights, a notion that has been used to defend the dignity of both incarcerated people and that of abused women? And how do these groups think through the fact that very often demanding accountability for human rights violations entails mobilizing the criminal legal system? What happens to our claims where international human rights bodies consider state due diligence to consist of deploying the mechanisms of prison? How do we engage with the legal world from a different world? This paper presents some preliminary findings based so far on 22 in-depth interviews, one focus group, and ongoing sustained interactions with anti-carceral and feminist organizers and activists. The participants are based both in Ecuador and the United Kingdom. In both regions, coercive and carceral tools to fight violence against women have been mobilized through international human rights discourse, including, for example, the Istanbul and the Belém do Pará conventions. Human rights penalty is identifiable in laws on domestic violence, human trafficking, modern slavery, among others. Thus, these case studies exemplify the synergies between international human rights and domestic laws in different geopolitical enclaves. Powerful feminist critiques of carcerality have emerged in both contexts as well. With this backdrop and using an anti-colonial lens, I explore the limits and possibilities of human rights for anti-carceral feminist work. The emerging findings reveal a broad skepticism regarding human rights language and tools, which converges with an aim to recenter the materiality of life, to not lose sight of the structural and economic inequalities that affect women disproportionately, and to continually reassess the strategic value of rights-based claims. In this way, feminist anti-carceral praxis is, I argue, repoliticizing violence against women. But before moving on to expound on these findings, I shall stress that Ecuador is undergoing a concerning and unprecedented crisis. Once a peaceful country, it is now the main port exporting cocaine to Europe. And the scenario of everyday shootings and killings, extortions and kidnappings, as well as brutal prison violence. Since 2021, riots have resulted in over 600 people being killed. This situation is largely the result of organized crime operations, which respond to transnational mafias. These territories of dispossession and death produced by the global capitalist economy urge us to further interrogate how international human rights justify the enhancement of penal apparatuses, as well as the reinforcement of a carceral common sense. At the same time, there is a paucity of scholarly work on how the grassroots, who may use the language of human rights, are responding to the phenomenon of human rights penalty. The exploration starts from the idea that the dominant interpretation of reality, that is, our hegemonic ontological assumptions, are largely the result of colonial power relations. Coloniality broadly refers to the persistence of paradigms, norms, and hierarchies introduced through colonization and imposed upon the colonized, thereby rejecting their knowledges and worldviews, what the indigenous peoples of the Andean region call their cosmovision. These colonial paradigms create deviant subjectivities that are marginalized and deemed less than human. If power structures both privilege and obscure certain ontologies, it follows that legitimate knowledge is also the result of struggles over truth and objectivity. Thus, the grounded experiences and knowledge production of anti-carceral feminists who resist the carceral common sense are often at odds with the dominant readings of reality that are found at the root of authorized legal knowledge. Indeed, the dominant ontology, which largely stems from colonial domination, is based upon the separation of the entities that compose reality and the notion of human autonomy, with a very marginal recognition of interdependence and interconnectedness with the environment and with other animals. The resulting epistemology separates subject and object, mind and body, human and nature, the I and the rest. This facilitates the juridical preeminence of abstract legal reasoning over embodied experiences. Separateness, abstraction, and transcendence broadly underpin the exclusion of lived realities, context, and material needs from juridical formation. In the role of penality, the universalization of prison as justice marginalizes alternative approaches, such as that of Andean indigenous systems in which incarceration is not generally a central mechanism. This universalizing an abstract model is prone to overlooking how prison violence is connected to formal privilege. The model is also insufficient to address the oppression that the penal apparatus exerts against underprivileged women, even those outside and around prisons, as I will explain. Also in previous work, I have mapped the colonial legacies present in early Republican and contemporary laws on family protection and domestic violence in Latin America. There are links between post-colonial nation-building narratives on the civic duty of motherhood, for example, and the regulation of domesticity and femininity in the region. Historically, the criminalization of domestic violence has often come about as a strategy to moderate violence, male violence in the home, and therefore preserve family. These deeply racialized and gendered processes have tended to reproduce colonialist hierarchies and construct the family as a space where national identity and citizenship are built often around ideals of Europeanness and whiteness. Coupled with contemporary rights-based discourse and amongst several competing approaches to countering violence against women, a jury-defined colonial and criminal law-centric model is dominant today. At the same time, international human rights principles and domestic constitutions justify and legitimize the criminal law framing of violence against women by elevating criminalization, as I said, to state due diligence and a fulfillment of international commitments as well. So a benign criminal law and a reformed prison are endorsed. This liberal penal minimalism fails to challenge the carceral common sense and leaves prison untouched. All the while, carceral violence aggravates and violence against women persists. These are the backdrops of this project through which I have learned that the meaning, implications, and uses of human rights are in permanent dispute. My conversations and regular interactions with anti-carceral feminists have taught me that alternative ontologies beget disruptive knowledges whose sense of justice is not limited by the carceral common sense. I have to start by saying that most participants are skeptical about the effectiveness of human rights tools in the context of their struggles. For the most part, they view human rights as a stabilizing framework that risks the co-option of radical social movements and provides minimal benefits for those who do not fit the middle-class prototype. Furthermore, the discourse of rights typically falls short in addressing the material needs and structural inequalities that are linked to violence against women. Symbolic individual rights are incorporated into one policy, doing little in practice to produce tangible improvements to issues such as housing, childcare, or healthcare. Moreover, the notion of due process can itself be a trap. It is built upon a false notion of equality, they said. Laws often cater to those with economic and social capital, perpetuating a system that prioritizes the privileged and masks imbalances under the rubric of neutrality. This occurs at the expense of challenging or transforming the system itself. Many participants associated the moral foundations of human rights with whiteness and white privilege, while human rights' relative blindness to racism was pointed out as well. This was the case during a focus group with Mujeres de Frente in the picture. This is a collective founded in 2004 inside the women's prison in Quito. The group includes incarcerated women, formerly incarcerated women, relatives of incarcerated individuals, self-employed street traders, urban waste recyclers, sex workers, domestic workers, academics, and students. In their view, mainstream human rights obscure everyday racist and classist violence, such as the one illegal street vendors suffer in the hands of police and municipal guards. Of course, most members of the collective would not be able to cover the costs of litigation to defend themselves in a trial. While the promise of human rights remains abstract, the threat of police violence and incarceration is always real for them. Likewise, as another activist and practitioner based in Ecuador argued, international law has mechanisms to address human rights violations, but they require specialized sponsorship and can take a long time to provide redress, which can discourage people due to re-victimization, financial costs, and the emotional energy required to be involved in litigating, even more so at the international level. In addition, the operation of human rights discourse at the local level can be problematic. For example, another participant who worked for over 2 decades as a health services volunteer in a rural community in Ecuador witnessed how women changed their understanding of domestic violence when they started learning about international treaties on violence against women, as well as local laws on domestic violence. And they were amazed that such laws even existed and that the state was taking a stance against the abuse they endured. Knowing that one has rights dignifies people and gives them a sense of support from institutions and the state. So human rights have an ethical power, symbolic power, and do remind us of certain dangers or risks of abuse. However, actually instantiating rights, especially through criminal law, can be conducive to harmful results. In this participant's experience, formally reporting violence and initiating criminal trials resulted in many women being subject to procedural violence, ostracism, retaliation by their aggressor, and other unforeseen consequences that were detrimental to their social relationships and personal integrity. In other words, the recognition of the self as a subject of rights through criminal law produced problematic consequences. Yet, despite this ambivalence, some of the participants utilized human rights as tools to advance some of their causes. Some participants identified a strategic value in human rights insofar as they enable certain conversations with governance agencies and international bodies, as well as legal actions in critical moments. In the UK, there are collectives that have used human rights concepts and materials as pedagogical tools for people inside prisons to understand their legal situation and that they are entitled to a dignified treatment. In Ecuador, some of the participants have used habeas corpus, engaged in litigation to demand the reduction of convictions to enable people to access medical care, or indeed to expedite the long administrative processes required to obtain release upon the completion of the sentence. A prominent example of a strategic and counter-carceral use of human rights is the case of the Committee of Family Members for Justice in Prisons, founded in 2022 in the aftermath of one of the cruelest carceral massacres in Ecuador. It is composed mostly of women, as you can see, and they have the assistance of a local NGO. The committee uses human rights tools to advocate the state's harsh treatment of the families affected by prison massacres, to advocate that it constitutes torture and degrading treatment. They are demanding state reparations through a constitutional action. And in support of this process, they have also interacted with international human rights bodies such as the Inter-American Commission on Human Rights. Importantly, through collaborations with other women's collectives in the region, this committee is denouncing that carceral violence not only affects incarcerated individuals, but also women outside and around prisons. Indeed, most carers of incarcerated individuals are women. Many are forced to pay a prison tax to corrupt networks of guards and organized crime gangs in order to provide their loved ones with minimal resources, or to be allowed to bring essential items, including medication, inside the prison. In addition, they are regularly subject to extortion by the gangs that control the prisons. This other carceral violence impacts impoverished women disproportionately and, as I argue, is a gendered form of penal violence. It is largely shaped also by the burden of unpaid care labor. Women looking after children and in charge of domestic work have great difficulties finding time and additional sources of income to cover the needs of their families inside the prison. The unveiling of this form of violence against women is another reason to rethink human rights penalty. And I'm going to give you one more example of strategic uses or subversion, if you will, of human rights, which can be observed in the endeavors of Socio Vivienda, a very deprived neighborhood in Guayaquil that has had the support of local human rights advocacy groups to undertake anti-carceral action. This neighborhood is considered highly unsafe and has been militarized several occasions. Despite numerous hardships, the residents have united to demand that the state grants them land titles for their current dwellings, which are in a situation of irregularity. Their motto reads, "Without deeds, there is no housing, and without housing, there are no human rights." This, as I see it, is an appropriation of human rights language by a community that is hyper-policed, whose population is routinely criminalized and stigmatized, where children and young men are recruited to become hitmen. Here, claims under the rubric of human rights do not entail a punitive trade-off. Rather, the demands include economic components that challenge the state and the elite over the monopolization of resources and the racialized dispossession of communities. So by centering access to housing, they are challenging the abstract nature of liberal legalism. Importantly, all these strategic uses that I referred to are not conducive to penal expansion. Rather, they aim at contracting the penal apparatus. So can we speak about anti-carceral or even abolitionist human rights? So there are a few issues to take into account still, because despite this strategic action, I will insist that the majority of participants still find many limitations in human rights or in rights-based claims in general. Because they require specialized legal advice, which is not very affordable, or they have to rely on legal aid, which is also not available all the time. And legal strategies demand unpaid administrative work, which often falls on the shoulders of women. And many participants also agree that prioritizing law or legal pathways could shift attention away from women's struggles for survival and the everydayness of the violence they experience. Indeed, some interviewees were concerned that demanding good prison conditions using human rights language while undoubtedly important, is very easily a strategy that takes the legitimacy of carceral punishment for granted and risks its normalization. As we see, the use of human rights uncovers various paradoxes. On one hand, there is a recognition that utilizing human rights may inadvertently perpetuate existing power structures, and prison reform operates on the assumption that prison itself is a necessary social institution. On the other hand, there is an understanding that one cannot not use human rights if there is a possibility of alleviating the suffering of individuals or groups at a particular time, including the suffering caused by dire living conditions inside prisons. So what we can learn from these uses of human rights is that they are recreating a language whose meaning is normally monopolized by local and international elites. It could be said that the strategic use is founded on alternative ontologies, which center interdependence and the materiality of life. There are significant differences between the way international human rights bodies use human rights and the strategies developed by local communities, which often stress economic and social rights, as you saw, and structural change. Rather than being committed to international human rights, these uses produce new forms of knowledge based on local cosmovisions and experiences. The term human rights may remain, but its meaning emerges from the emancipatory struggles of people who are resisting legal and penal violence. This is different from the language used in the halls of international courts or international organizations. The investment is not in human rights per se, but in bringing penal violence and social inequality to the center, strategically using some tools that can produce results in specific cases at particular junctures. Moreover, the counter-carceral nature of these demands shows that reframing and repoliticizing violence against women can occur by decentering penality and recentering the resources needed to survive and thrive. In other words, tracing penal violence against women, such as that impacting individuals who perform unpaid care work around prisons, brings the materiality of life to the forefront, starkly showing the limits of law and the need to de-juridify justice. This implies repositioning the body, the community, and public goods as starting points. A life with dignity cannot be lived without access to housing, healthcare, food, and a thriving community. The social and economic refocus can in turn weaken the dominance of penality in the realm of violence against women and human rights. Mujeres de Frente, again, is an example of what I have just described. This collective is frontally anti-carceral and anti-racist. In their projects, they prioritize women's material requirements. Together, through the years, they have put together community initiatives that include a childcare facility, a food bank, a small savings fund they redistribute among the members, and a political school for women. To conclude, I will leave you with the argument that an anti-colonial feminist agenda ought to engage with penal abolition. Gomez and Gomez have suggested we take elements from Latin American decolonial theories and also from classical abolitionism to propose a decolonial abolitionism. The knowledge shared by the participants in this project indicates that carcerality is gendered and racialized and should, as a consequence, be decentered as a signifier of justice. Penality widely informs the way in which human rights are understood, and the prevalence of these formations, together with the continuity of conservative discourses regarding gender norms, have determined a legal construction of violence against women that dismisses the legal realities of those who attempt to access justice. Therefore, penal abolition emerges as an anti-colonial praxis that can disrupt liberal legalism by rejecting the racist and misogynistic violence of the penal apparatus. A recurring pattern emerging from this work with grassroots collectives is the idea that an anti-colonial stance entails contextualizing the abstract and focusing again on people's material needs. Also, the participants' experiences suggest that an anti-colonial and relational justice cannot be practiced outside of collective deliberation. So I have not addressed a question that is around, which is it possible to decolonize human rights? Or is it rather that an anti-colonial project would entail the transformation into something else altogether? The word human itself is problematic for certain cosmovisions that consider that there are non-human animals that are sentient, for example. And I'm not addressing that question today, but I do consider that resisting the carceral dimensions of human rights is key for an anti-colonial agenda. Mobilizing the carceral dimensions of human rights may compromise key commitments, which include the struggle against racism and against the criminalization of women's struggles to survive. Put differently, an anti-colonial feminist agenda should incorporate penal abolition and move toward a model of justice that centers contexts, interdependence, and access to resources required for a dignified life. And for advocacy, adopting a counter-carceral stance within human rights could be a strategy that contributes to dismantling the hegemony of penality. Moreover, even those working within and with the international human rights tools in those large halls of power in the international courts, I think, should turn their eyesight to these examples, to start rethinking and considering reframing what has until now been the mainstream understanding of violence against women. Today's mainstream understanding of violence against women mostly framed as a juridical and as a criminal legal issue. Yes, these are some of the ideas from this project, and yeah, I'm looking forward to having a conversation about it. Thank you very much.
Very much. So the floor is open for questions, comments.